Hi, everyone. My name is Alexis Eykel, and I am the Landlord Engagement Specialist at Tacoma Housing Authority. And today I'm really excited to introduce our friends over at Tacoma Probono and Landlord Solutions. They are going to be talking to us about deposits and holding fees. And please note the law will be changing a little bit July 23rd, and this training is not specifically going to address those changes, so stay tuned for more information in the future. I am going to launch a poll here in a few minutes. And just to let you know, we are going to record this webinar, and William and Jim are going to do a presentation, and then we'll stop and open it up for questions and answers. If you want to ask questions, please use the question and answer box at the bottom of your screen. And then I'm going to go ahead and turn it over to Jim Henderson with Landlord Solutions and Will Beck with Tacoma Pro Bono. Thank you guys so much for joining us today.
Thank you, Alexis, for that introduction. Hi, everyone. My name is Will Beck. I'm the Assistant Managing Attorney at Tacoma Pro Bono's Housing Justice Project. I'm super excited to be here today.
Thank you, Will. Thank you for Alexis for being here to educate and to bring just some best practices as reminders to our housing providers in the community. As Alexis said, Jim Henderson, I'm with Landlord Solutions, but I'm also a local and state lobbyist, and I represent the Rental Housing Association, which many of you may be a member of.
All right, so I think we can go ahead and get started. I'm going to try to share my screen here so we can get the PowerPoint slides up. All right, and Alexis and Jim, are we good? Awesome. All right, so as Alexis mentioned, we're here today to talk about security and damage deposits and also holding fees under the Residential Landlord Tenant Act. So to give you a quick overview of the topics we're going to cover today, we're going to talk about security and damage deposits, the requirements in terms of collection of those deposits, and documentation, what the limitations are on security and damage deposits and retention of security and damage deposits. Also the process of move out and what that looks like in terms of providing the statement and providing any refund that's due to the tenant, and the ability of a tenant to request installment payments, what that looks like if a tenant does request installment payments, how a tenant requests installment payments, and what the limitations are on those installment payments. We're also going to talk briefly about the option under the RLTA to pay a fee in lieu of security or damage deposits, the requirements associated with that, the limitations and the remedies for violations if that is improperly handled by a landlord. And then lastly, we're going to talk about holding fees under the RLTA. We'll get into what that means later on in the presentation, and again, the requirements and limitations there as well. So to kick us off briefly, it's important that we highlight kind of what exactly we're talking about here when we mean damage deposit and security deposit, because security deposit can be thrown around broadly. In fact, Jim and I had a discussion earlier today about using the term broadly and how we distinguish those. So a damage deposit, when we refer to damage deposit, we're referring to a deposit that's used just to cover the cost of physical damages to the unit that occurred during the tenancy. So when we're using a strict damage deposit, that is not something that's going to cover any non-damage related losses from the tenant's lease. So it's not something that the landlord can retain to use towards unpaid rent. On the other hand, a security deposit is a broader deposit that can be used to secure a tenant's fulfillment of the terms of the lease. And that, as opposed to a damage deposit, can be used to cover losses that derive from the tenant's lease violations. So as far as security and damage deposit requirements under the RLTA, this comes under 5918-260, where a landlord requires a security or damage deposit, the lease has to be in writing. And so if you have an oral lease with your tenants, or tenants, if you and your landlord have an oral lease agreement, it's going to be improper for a security or damage deposit to be collected, because we need to make sure that there are terms in a lease agreement that speak to, you know, what the deposit is going to, how the deposit is going to be retained, and where it's going to be retained, and so forth. Also, as I just said, you know, it must state the conditions under which the landlord may retain the deposit or any portion of it at the end of the lease. In addition to those two requirements, a move-in checklist is also required if there's going to be a security or damage deposit that's collected at the inception of the tenancy. That checklist has to specifically describe the condition and cleanliness of or existing damages to the premises and furnishings. The checklist has to be signed by the landlord and the tenant, and the landlord must provide a copy of the checklist to the tenant. Throughout the tenancy, if the tenant at some point loses or misplaces the checklist, the tenant has a right to request at least one free replacement copy of the checklist. This comes into play a little bit later as we talk about move-out procedures and what that looks like in terms of retaining parts of the security deposit or all of the deposit, and also what the statement that's required to describe any basis for retaining part of the deposit. But we won't get into the weeds as far as that just yet. Also, as many of you have probably heard before, no amount of a deposit can be withheld on account of normal or ordinary wear and tear. So minimal damages, right? Those are not things that can be retained. Those are not bases for a deposit to be retained. Jim, is there anything you want to add there for our landlords in the audience?
Yeah, I just want to emphasize that the move-in checklist must be completed, and it must specifically describe something. I often see is it'll just say okay and then a line drawn down the column. That's not considered completed. And then when you're describing the cleanliness or the the condition of the unit, words that are not subjective. So you want to say working, not working, damage, undamaged. If the item does have damage, you should find something to give a scale to that damage and take a photo, whether it's a quarter or it's a ruler, and specifically describe where is that damage. If it's on a countertop, it's left, upper corner, something that gets really clear, so that you can differentiate that was existing from something that happened during the tenancy. And then I think the last thing I'll add is that keep in mind that when we get to like the move out side, is on the tenancy, that you're actually looking at your the actual cost of damage. So be thinking about through the lens of, when you're describing that, can you accurately then compare that to a move out?
And I'll add on to that a little bit, Jim. Speaking for myself as a tenant in past situations, it's easy for tenants to on both sides, but particularly, in my experience on the tenant side, to just go through that move-in checklist as quickly as possible, and try to get it done, because you want to move in, right? You want to get settled and start moving your things in and settle into your new place. But with that being said, what the importance of the move-in checklist can't be understated, I think, on either side, because it's making sure that's done thoroughly is going to avoid the potential for future conflict at move out. Now, if a landlord collects a deposit without providing a written checklist at the commencement of the tenancy, the landlord may be liable to the tenant for the amount of the deposit. And in an action to recover the amount of the deposit, the prevailing party may be awarded a court costs and reasonable attorney's fees. In terms of where or how the deposits are stored, security or damage deposits must be promptly deposited into a trust account that's maintained by the landlord for the sole purpose of holding such security deposits or damage deposits for the tenants of that landlord in either a financial institution or a licensed escrow agent located in Washington. And unless otherwise agreed in writing, the landlord is entitled to the interest paid on the trust account deposits. At the inception of the tenancy, when that deposit is paid, the landlord must provide the tenant with a written receipt for the deposit, and also written notice of the name, location, and address of the depository. So wherever that, let's say it's stored in a bank account at Bank of America, then the tenant needs to know in writing exactly where that's at. If the name, location, or address changes, the landlord has to provide written notice of that change.
just for those who don't know the background on this, kind of, this part of the law, the reason that this is designed the way it is because the deposit money is not yours. As the housing provider, that is still your resident's money, and you can use it according to what we just described on the move out if there's damage. But while that money is still theirs, and why you have to keep it in a separate account is because in a situation, let's say that you file for bankruptcy or that you are sued, well, then that money is an account that while your name's on that account, you can separate off and say, this is not my money, this is deposit money, and it still is then available to your resident during their tenancy. So that's why they require you to have a separate account for it, and you can't just put it all into one account. And they want to make sure that, probably most importantly, that you don't use it for operating expenses, so that when the resident moves out, you don't have the money.
So now we'll move on to the move out procedures and what those look like. So after termination of a rental agreement and after the tenant has vacated the premises, the landlord has to give a full and specific statement of the basis for retaining any portion of the security or damage deposit, together with the payment of any remaining portion of that deposit. And that needs to be delivered to the tenant within 21 days after vacating. Again, just another reminder, no portion of that deposit can be withheld due to ordinary use of the premises. And as far as delivery methods, the landlord must either deliver the statement and payment, if applicable, to the tenant either personally or by first-class mail, postage prepaid to the tenant's last known address. So for the tenant, for our tenants in the audience, make sure that whenever you're vacating, that you leave your new address with your landlord, because there's not a requirement that they track you down and get this statement and partial or full refund back to you. The requirement is that they put it in the mail to whatever address they have the last address that they have for you. As Alexis mentioned at the beginning of this presentation, as far as what we're covering in today's presentation, we're covering the laws relating to security and damage deposits as they stand today, June 23rd. And so with that being said, we are expecting some new laws to take place and be in effect as of July 23rd. And in particular, it's going to impact the way that we handle the move out statements and return of damage deposits and security deposits. In particular, without getting too far into the details, for lease agreements that commence on or after July 23rd, 2023, the move-out statements that arise from those tenancies must include copies of estimates received or invoices received to reasonably substantiate damage charges. So not only can you submit an invoice saying, hey, this is what we're taking out of your deposit because of the damages that we found in the unit. Here's an estimate of the cost that it's going to take for us to make repairs to those damages.
I recommend that if you are a member of a housing association, that you take advantage of the training that they're doing right now to educate their members on changes to the deposit documentation. Because as Will said, that there's more compliance under the upcoming new law on July 23rd for the move-in documentation, as well as the move out and what you can and having supporting documents for the deductions. So there's more to learn there. And the other comment I'll make is just for the housing providers that if you don't have your, if you send your deposit disposition and refund out to your resident's last known address, and if it comes back to you, make every effort to try to communicate with them via email or phone to try to sort that out. But if you're unable to get a different address, be sure you just keep that envelope showing that it was returned, and you just put it in a file and hold on to that for quite a while, just so that if in a couple of years the resident comes back and they now have, they remember or they see your email, whatever the situation is, then that's still available to them.
Now, if the landlord fails to provide the statement and refund within 21 days, as we had just discussed, the landlord is liable to the tenant for the full amount of the deposit. And in an action to recover the amount of the security or damage deposit, the landlord can't raise claims for recovery of the deposit, nor defenses to retaining the deposit, unless the landlord shows, either that there were circumstances beyond the tenant's control that prevented the landlord from providing the statement within 21 days, or that the tenant abandoned the premises as defined in RCW 5918-310. And so unless there was evidence to indicate that the tenant abandoned the premises, or there were some extraordinary circumstances that prevented the landlord from getting the deposit and the statement back to the tenant, if the tenant later comes back in a civil action to recover the amount of the deposit, the landlord's going to be barred from bringing these defenses. So this is something that the RLTA is taking super seriously. In such an action, the court may award up to 2 times the amount of the deposit if they find that there is an intentional refusal of the landlord to give the statement or refund due. And again, the prevailing party in such an action would be entitled to an award of reasonable attorney's fees and costs.
Some common mistakes that I see housing providers make at this step of the process is when you're not calculating your 21 days from the date that your resident vacated. So you're picking a different date. And so the common one that I see is, well, the lease was ending at the end of June, but they moved out June 20th. Well, the 21 days to return the deposit doesn't start after the lease expired. It starts after they vacated. And by the way, if they notify you by phone, hey, we're moving out today, technically that is when you should start your time computation on your 21 days. Another common mistake is that your vendor can't go out there and fix it, or give you a receipt within the 21 days. That is not your resident's problem. This is one of the things that the court takes very, very seriously. That you're able to use the deposit for actual costs, things that might become a cost, or you don't know what the costs are. It's been decided that you would have to then use the small claims process for those. Now, going back just a slide, on July 23rd, for those new tenancies, you can use estimates, but under the current 21 days, you're not able to use an estimate for your basis. So just note that you've got to, and I know that's a lot of work within 21 days because we're all using our vendors, we're doing all the same work at the same time, but these are common mistakes that are made, and there's no explanation for it that is been accepted in cases where the landlord has been brought before a small claims judge.
All right, so we're going to move on just a bit here to talk about deposit installment payments. So this comes under RCW 5918-610. So under the RLTA, at move-in, a landlord must allow a tenant to pay any deposits, non-refundable fees, and last month's rent in installments if the tenant requests in writing to do so. Now that applies for the most part, unless the total amount of the deposits and non-refundable fees do not exceed 25% of the first full month's rent, and payment of the last month's rent is not required at the inception of the tenancy. And so the only situation where this wouldn't apply is where you have a lease agreement that requires a relatively small amount of deposit and refundable fees, and also does not require the payment of last month's rent at the beginning of the tenancy. If the tenant chooses to elects to use this in writing, the installment schedules must be in writing as well and signed by the landlord and tenant. And a landlord is prohibited from imposing any fee, cost, or charge any interest based on a tenant's decision to pay in installments. Now, there's also some distinguishing factors in terms of the number of installment payments you can make. It's not a huge distinction, but it's something that we all should know. If the lease term is for 3 months or more, the tenant may elect to pay any deposits, non-refundable fees, and last month's rent in 3 consecutive and equal monthly installments, the first payment being due at the inception of the tenancy. And so as long as the lease term is for more than 3 months, the tenant then has 3 months to make those installment payments. And essentially you would take the total amount of the deposits plus the non-refundable fees and last month's rent divided by 3, and the tenant is obligated to make equal 3 payments for the first 3 months of the tenancy. The only situation where that wouldn't apply is where the lease term is shorter than 3 months. In that case, the tenant can essentially split the total of the deposits, non-refundable fees, and last month's rent into two and make two equal payments during the first 2 months of the tenancy. As under the RLTA, the installment payments are due on the same date the monthly rent is due. If a landlord refuses to permit a tenant to pay any deposits, non-refundable fees, and last month's rent in installments, despite that tenant's written request, the landlord may be subject to a statutory penalty of 1 month's rent and reasonable attorney's fees payable to the tenant. Now, on the other hand, if there's an installment plan between the landlord and the tenant defaults on the installment plan for the deposits and fees, the landlord may treat the default in payment as rent owing and then proceed with a non-payment notice, similar to a non-payment eviction. So essentially, if there's a default on the installment plan for, even though it's not considered rent before that, if there's a default on the installment plan for the deposits and non-refundable fees, that default can then essentially converts, as far as we consider under the law, that to be considered as rent for the purposes of serving a 14-day notice. And then the RLTA distinguishes non-refundable fees from deposits. Under the RLTA, non-refundable fees cannot be designated as a deposit or as part of any deposit. If a landlord charges non-refundable fees, the lease agreement must be in writing again, and shall clearly specify that any such fees are non-refundable. If there are fees that are sought that the landlord seeks to have be non-refundable, but the lease agreement does not specify within that those such fees are non-refundable, then in that case, the fee must be treated as a refundable deposit. At that point, if it doesn't speak to it in the lease, then it's treated as a refundable deposit rather than non-refundable. If the landlord fails to provide a written lease agreement but collects non-refundable fees, the landlord is liable to the tenant for the amount of any non-refundable fees collected.
Hey, Will, on that, just as a reminder for the housing providers, that if you collect a $250 cleaning fee and the cost to clean was more than $250, you cannot go back and ask for the difference. You are capped out at whatever the fee was for that item. That's your cap on that item, okay?
All right, so moving on to the option of paying a fee in lieu of a security deposit. Landlords can waive a security deposit and allow a tenant to pay a fee in lieu of a security deposit. But in doing so, they must ensure that the fee is strictly optional for the tenant. So it's not, the landlords can offer this as an option, but it has to be an option that's decided by the tenant. If the tenant chooses to pay a deposit instead, they're more than welcome to do that. Also, if it's something that landlords that you're going to offer, it needs to be an offer it needs to be an option that's offered to every prospective tenant. It can't just be on a case-by-case basis. It needs to be an option for any prospective tenant who has been approved without regard to income, race, gender, disability, source of income, sexual orientation, immigration status, size of household, or credit score. Also, landlords, if the option of paying a fee instead of a deposit is offered, you must allow any tenant that agrees to pay a fee to opt out of the continuing fee option upon full payment of the security deposit. So let's say you have the option, you hold out the option, the tenant accepts to pay a monthly fee rather than engaging in paying a security deposit up front. The tenant at some point may decide, I don't want to pay this monthly fee anymore. I'd rather just provide a security deposit. If they pay that security deposit in full, they can choose to do so. Going back to the importance of providing a move-in checklist at the inception of the tenancy, that's also a requirement. Not much changes there, because if you're collecting the deposit anyways, you will be required to conduct that move-in checklist. But it's just restated again here in this provision. Lastly, this is a bit complex, but the landlord must disclose to the tenant the terms of any insurance coverage purchased by the landlord to cover the landlord's losses arising from the lease and any exclusions or caps on such policy. So essentially, and Jim, feel free to correct me if I'm wrong, the purpose of gathering or collecting this fee from a tenant in lieu of a security deposit is so that the landlord can seek to an insurance policy that would cover anything that the security deposit otherwise would in the absence of a security deposit.
Yeah, I mean, that is one of the benefits to the program. However, the initial intent, so I put my lobbyist hat on when we were working this bill, the original intent, and this bill was brought by a company called LeaseLock, and ironically, this product is not available in our state. Nobody uses this because it's not that it's not available, but that the companies that offer this, they either, one, they're not insurance company, which is a requirement, or they have a license with our state as an insurance company, and or the company it integrates only with a certain software providers, and if you don't use software, then you're not eligible to use it. But the original intent of this bill was to lower the move-in costs for residents and to give them an option that still then worked for the landlord, getting what would be the security of a deposit, while making it, the resident would have to come up with that much more money for the deposit all at once.
Thanks, Jim. So I include this here. Granted, all of these slides with respect to fees in lieu of a security deposit will be limited by what Jim had just explained, but there is some statutory disclosure language that needs to be included if a landlord and tenant elect to do this. You can find this in RCW 5918-670. Any fee in lieu of a security deposit may be entirely or partially non-refundable, so long as it's disclosed in the lease and separately acknowledged by the tenant. Earlier in the presentation, we discussed how a default on an installment may give rise to a non-payment eviction under 650 RCW 5918-652A. A fee in lieu of a security deposit does not constitute rent, and failure to pay may not constitute a just cause for eviction under 5918-650. However, if a tenant, if this is an option that's utilized between landlord and a tenant does not pay the fees that are due, the landlord is not precluded from filing a civil suit to recover unpaid fees. Lastly, any fee in lieu of a security deposit must be utilized by the landlord to purchase insurance coverage for the landlord's losses. This is something that Jim and I had just discussed in the last slide, so we won't focus too much on that. Jim, is there anything else you wanted to add on this?
No.
Okay. Now, if in terms of changing fee waiver terms during the tenancy or discontinuing the option, a landlord cannot discontinue or alter the terms of the insurance during the term of the rental agreement if this is something that's used. If the landlord decides to discontinue providing the fee waiver option at the end of the lease term or period, the landlord must first provide 60 days notice to the tenant prior to the end of the term or period. The landlord must also reduce the deposit by the amount of a tenant's previous fee payments in lieu of a deposit. And the landlord must offer the tenant an installment plan to pay any remaining balance for the security deposit over 3 months. So if this option is used, but there's a material violation of the terms of RCW 5918-670, so if the landlord materially violates any of the requirements that we just discussed with respect to a fee in lieu of a security deposit, the landlord shall be held liable to the tenant in a civil action up to 2 times the monthly rent, as well as a reasonable attorney's fees and costs. One thing to note here is that it's not just the statute intentionally use material violation, and so it has to be something relatively egregious compared to like a minor oversight, and so the remedies are somewhat severe, 2 times the monthly rent, but it also has to be a pretty egregious violation. All right. So now we'll talk about holding fees. This is, I think, the biggest shift that we have in our presentation thus far. We've spent most of our time discussing security deposits, and damage deposits, but now we're shifting gears and talking about holding fees. Now, when we're talking about holding fees, we're referring to fees that are paid by the tenant to the landlord to either hold a dwelling unit or secure that the prospective tenant will move into a dwelling unit. It is not referencing a fee that's paid for the privilege of being placed on a wait list to be considered as a tenant for a dwelling unit. With respect to the holding fee to hold a unit or to hold a unit in the complex, that is permissible under the RLTA. However, a fee to be placed on a waiting list for a particular unit is not permitted under the RLTA. So a landlord who charges a prospective tenant a holding fee must provide a receipt for the fee together with a written statement of the conditions under which the fee may be retained. There is a cap on holding fees, and a landlord may not request a holding fee in excess of 25% of the first month's rent. So let's say the first month's rent is $2,000, 25% of that being $500. The holding fee for that unit or for whatever unit in the building that the tenant is seeking to hold cannot exceed $500. If the prospective tenant ends up occupying the unit, the landlord must then credit the amount of the holding fee to the tenant's first month's rent or to the tenant's security deposit. On the other hand, if the prospective tenant does not occupy the unit, the landlord may keep up to the full amount of the holding fee so long as it was in accordance with the written conditions provided upon payment of the holding fee.
So make sure that your written statement describes what the fee is being held for, how long it's being held for, and what happens if, well, and let me back, and what the resident or the applicant at that time needs to do in order to to take possession or to convert this into a security deposit, which naturally they would need to come in and sign a lease. And you need to put a date on it. You need to have a date in which all of this is to be due by, and for it to be very clear as to what the expectations are as to why I'm holding it, for how long I'm going to hold it, and under what conditions would you receive a refund or not receive a refund. You can't over communicate this. The other thing is, keep in mind that the resident's first month's rent, if your resident is using a voucher and their portion of rent is $100, then the holding fee would be based on their portion of the rent. Okay, not for the full amount of the monthly rent, only their portion.
Thank you, Jim, for clarifying that last point in particular. I think that's something that gets lost easily when we're talking about subsidies, not just in this context, but in many contexts. So I appreciate you pointing that out. And then as far as remedies, in any action brought for a violation of the holding fee statute, the landlord may be liable for an amount up to 2 times the holding fee, including attorney's fees and court costs.